Hi everyone, Shaun here from Help and Partners with a special guest. We've got Melinda Foley from MacDonnells Law here to talk us through some of the HR challenges all businesses are having in dealing with the JobKeeper payment and various other staff issues brought on by the coronavirus crisis. Melinda, I thought we'd start off with a question that a lot of people are asking in relation to the JobKeeper scheme. Do employers need to make the JobKeeper scheme available to all of their staff, or can they pick and choose who is eligible?
The preferred view, Shaun, is that they have to make it available to all eligible employees and they can't be selectively nominated.
Okay, so can we just run through a few examples, Melinda, of different classes or types of employees, just so we can confirm who is and isn't eligible? So staff who have already been stood down by an employer and maybe are on the Job Seeker program, are they eligible to enter the JobKeeper program?
Yes, Shaun, as long as they meet the two key eligibility criteria, which is that they were employed either on a permanent basis or long-term casual as at 1st of March, and they remain employed, then they will be able to be nominated. For stand-down employees, you are currently employed and hence there's no issue there.
Okay, what about staff who have already been made redundant by an employer?
Again, you need to meet the two key eligibility criteria. So they have to have been employed as at the 1st of March on either the permanent or long-term casual basis, and then they have to be employed at some point during each JobKeeper fortnight that you claim for. So that means that you'd need to re-engage any employees that have been terminated if you want to claim for them. And the time of claim runs from the time of re-engagement. So if you re-engage now, you would be able to claim from JobKeeper going forward, but not retrospectively.
Melinda, I understand in relation to casual employees, they need to demonstrate 12 months worth of employment history with an employer to qualify for JobKeeper. In our region, we have several industries where they have seasonal casual employees, could be tourism or fishing or agriculture, for example. Can someone who has worked on a seasonal basis for say 2 or 3 years satisfy the 12-month eligibility criteria as a casual employee, or do they need to have, a continuous 12 months worth of engagement?
That's quite a difficult question, Shaun, and we would recommend people get specific advice, but there is 3 things that employers should look at when assessing that. Firstly, they have to establish long-term casual employment for the prior 12 months, which means a regular and systematic pattern of employment. If that regular and systematic pattern can be shown for particular chunks of employment over the 2 or 3 year period, then you might be able to establish that. But you would need to make sure that you can show a very regular frequency and an expectation of ongoing work. So the longer the historical period you've got, the better. Secondly, you have to show that they were a current employee as at the 1st of March, which means that they will need to have been on some sort of understood unpaid leave if they're on that seasonal break and there was continuity of employment, not that they rehire each season, because if they're rehiring, then the chain is broken each block. And thirdly, they'll have to be a current employee during each JobKeeper fortnight. So again, that will very much link. If you're on that unpaid leave, you're in a seasonal break, always very regular, then you might be able to meet it, but you will have to be really careful at looking how much regularity and pattern you can show. Okay,
good advice. Melinda, I've had lots of businesses asking me whether they're able to have their staff work for their JobKeeper payment, perhaps doing reduced hours or different tasks. Can you provide any guidance on that?
Yes, Shaun. The government has amended the Fair Work Act in line with the JobKeeper subsidy to provide more flexibility to employers, but there is limitations to that. So there is a ability to issue directions to reduce hours, to change duties or change location of work, but that is subject to that being reasonable, it being safe, and the duties being within the normal scope of the employer's business. In relation to reduction of hours, you need to show that the reduction is due to that specific employee's job being affected by COVID. For the other directions, it's the wider employment force needing to have the changes to preserve employment overall. So there's more flexibility with that. You need to consult, so you have to give 3 days written notice, and then you need to have a consultation process with your employee and then issue in writing. There isn't an ability to unilaterally increase hours or to change specific days or times. So if people normally work Monday to Friday, you can't make them work Saturday and Sunday, and you can't put them on night shift. That has to be a process of agreement. There is been a change there that the employee can no longer unreasonably refuse. But what is unreasonable is, going to be subject to Fair Work Commission hearings, and it takes into account things like their other responsibilities, other jobs, caring, family, all of that type of stuff. So definitely within the scope of what they normally did, and some shift in duties is fine, but you can't make a person who was doing 8 hours a week suddenly work 15, because that's what the JobKeeper hours are.
Would you recommend any employer who is varying the hours or duties of employees document that in writing?
Yes, it's a requirement of the Act that it has to be in writing, so you need to do it first for consultation, and secondly then issue it in writing. It expires on the 27th of September automatically, so it can't go past that, so people need to keep that date in mind. And if you're doing it by agreement, which is also another way to do it other than purely under the Fair Work Act, that should be documented. Can just be an exchange of emails where you confirm this is what we discussed, and the employee writes back, yes, I confirm agreement with that. Doesn't need to be particularly formal, but certainly the formal directions should be kept as part of your workplace record keeping with wages and things like that.
Melinda, can you clarify something for me in relation to employees taking annual leave? Where an employee is unable to fulfil their normal employment duties as a result of the coronavirus, is their employer able to mandate that they take annual leave while they're receiving the JobKeeper payment?
Shaun, there's two sources of power around that. There's the awards, which people would need to look at individually, because there has been some amendments to those. But there's also been an amendment to the Fair Work Act that only applies if you're eligible for JobKeeper, which allows employers to request employees to take leave, and that must be considered by the employee and not unreasonably refused. The employee has an entitlement to maintain a minimum balance of 2 weeks leave, and whether they say yes or no to the request is still a matter of discretion for the employee, but it is subject to that overriding requirement of reasonableness, and any dispute on that can be referred to the Fair Work Commission.
Okay, thanks Melinda. And again, do those arrangements need to be documented?
Yes. Well, the leave requirements would just be subject to your normal leave, but we would recommend that it always be put in some sort of written form that there's been a request and what the employee's response is to that.
As you can see, the HR issues that businesses are facing at the moment are very complex and require professional advice. The right advice for your business, yourself and your staff.